Hi, and welcome to Hull & Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull, partner at Hull & Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull & Hull TV, we're exploring the issues around estate planning that affect you. Ian, we've been talking about the crossover between family law and estate planning. Let's look at some of the more recent cases that help illustrate. Kerrigan versus Kerrigan is a timely reminder of the need to keep your financial affairs in order, especially when your family circumstances change.
Well, it really is, and it's a fun case. I don't love reading cases and poring over the facts all the time, but the Kerrigan story is a fascinating story, and it went right to the Supreme Court of Canada. Leave to appeal was recently refused. So it is sort of established as the benchmark now of the law on one very important part of family and estate law, and that is the question of pension benefits, where they will pass on death. And up to the time of Kerrigan and Kerrigan, there was some comfort with what the rule we used to call, not very legally refreshing, but the spouse in the house. And the rule being that if you're the spouse and you're in the house, you're going to get the pension. And some statutory provisions of pension benefits already engaged to ensure that that's going to happen. But in the Kerrigan decision, dealt with an Ontario pension battle, and the final result was that the deceased hadn't changed his designation of beneficiary for this pension benefit, hadn't gone to the trouble of changing it. And on his death, he was in a second relationship, a common law relationship at the time of his death, and his first wife ended up enjoying the benefit of the pension benefit. And it was a very technical point, but a constant reminder to us that a very, very large asset of many people's estates can flow a direction that was maybe intended, maybe it wasn't.
The Ontario Court of Appeal decision in Spencer versus Riesberry is also getting a lot of attention.
Well, it is. And again, it's just sort of, these are good cases to think through as practitioners and for those of us who are trying to organize our affairs and we're going to go see a lawyer, because the Spencer decision also talks about the struggle with arrangements where we'll see it in many cases, and that is where a family has, during their lifetime, created a trust. Or maybe a generation before has created a trust. And there are assets in the trust that come under attack on separation in a family dispute. And are those trust assets available to a spouse that has separated? And the Spencer decision was a really fulsome decision and an interesting read for those of us who are interested in the trust law, but an interesting read on the court's reaffirmation of the importance of a trust, that it is a barrier to a simple attack from a family law perspective on separation. And the Court of Appeal reminded us of that reality.
Walk us through the Reed decision and how it deals with that recurring issue of the rights of a common law spouse.
Well, the Reed decision it's not as current because it didn't have to be said recently. It was a decision about 10 years ago where the court reminded again, and this was a great illustration of practitioners that needed to be said, and that was, in that case, a surviving spouse had her common law partner had passed away, and she had determined that there wasn't enough in the will for her liking and her needs, and so she brought a claim for support, for additional support beyond what was set out in the will. And the court, and in the course of bringing that claim, the court said, well, look, you can't be both executor and claimant. So you can't have it both ways. If you're going to sue the estate, you can't stay on as executor. So although the surviving spouse in that case was removed, from a practical standpoint, it allows us as practitioners to make sure that we go to the trouble of saying to our clients, well, look, if you're going to sue the estate, you may be giving up something, and that is control over the estate. And depending on the circumstances, it may or may not be a good idea.
Hanson Estate versus Hanson is an interesting case that deals with death, property, and a separated couple.
It is. And again, these are another handy illustration. And that case has very widely been regarded in the family law bar and the estates bar as a great illustration of the importance of conduct. If you behave like you are separating, the court will tell you you have separated. And in the Hanson case, there was a debate over whether or not conduct on the part of the two parties, the separating parties, was sufficient to sever the joint tenancy. So this happy couple bought a property, put it in joint tenancy, but in the course of their separation, their conduct, by just saying they're separating, that was sufficient to be legally splitting the ownership interest into tenants in common, which meant that they were in a 50-50 ownership position without taking any legal steps beyond letter writing between the lawyers.
These are the sorts of complicated issues that families want to avoid when estate planning. So what can we learn from these cases?
Well, a big part of it is the intake. So I look to make sure I've got a handle on what's going on with the pension benefits. I got a handle on the ownership of each of the assets, and I've got a handle on what the parties actually want to achieve. Do they want to leave an estate the way it was before to make sure that the first spouse has enough and enough for the second spouse, or do they want to wipe out the first spouse's interests, or how do they want to do it? Looking at what they want to achieve is a big part of a good plan.
Good advice. And thanks for joining us on Hull & Hull TV.